The sun hadn't fully cleared the ridge when I heard the sound of engines rolling up my gravel drive. Not one vehicle, three. I stepped off the porch in my boots, still buttoning my flannel, and I grabbed my shotgun from beside the front door, same as I did every morning before checking the fence line. When I rounded the corner of the house and saw them, Doug Whitfield in his khakis, Karen Pruitt clutching that clipboard, and two men in polo shirts I'd never seen before, all of them frozen at the edge of my property like they'd just walked into a rattlesnake den. I didn't raise the gun. I didn't need to. Karen dropped her clipboard. Trevor was already halfway back into the car, and Doug, the man who had spent 8 months trying to tell me I didn't own my own land, couldn't find a single word to say. This is the story of how the Harmon Ranch fought back and won. My grandfather, Earl Harmon, broke ground on this ranch in 1941 with a mule, a plow, and $37 to his name. He'd come out of the hill country of central Texas with nothing but a work ethic and a stubborn street that could bend iron, and over 20 years he turned raw limestone scrubland into a working cattle operation. When he handed it to my father, Raymond Harmon, the deeds showed 382 acres, a main house, 2 barns, a hayfield, and water rights to the creek that cut through the eastern edge of the property. I grew up on that land. I learned to ride before I learned to read. I pulled calves in February mud before I ever sat in a classroom. When my dad passed, a heart attack on a Tuesday morning in October, 12 years ago now, I was 40 years old and already running half the operation myself. Becoming sole owner wasn't a celebration, it was a weight. A responsibility I'd been training for my whole life, but one that settled on my shoulders like a yoke all the same. My wife May had grown up on a neighboring spread, and she'd married into the Harmon operation without a single complaint. May was the kind of woman who could read a land survey plat like a novel and balance a cattle operations books while simultaneously handling a difficult calf birth. She was my partner in every sense of the word, and the ranch would not have survived the last decade without her. We had 2 full-time ranch hands, Hector Reyes, who'd been with us for 16 years and knew every inch of our fence line better than his own front yard, and a younger man named Cody, who handled equipment maintenance. Between the 4 of us, we kept 300 head of Angus cattle, a small horse herd, and about 40 acres of hay production running year-round. Our nearest neighbor and oldest friend was Buck Tillman, who owned 190 acres just north of our property line. Buck was 61, widowed, with a voice like gravel in a coffee can and an opinion about everything. He'd been the first to mention the development. It was about 3 years ago, maybe a little more. I was fixing a section of fence along the highway when Buck pulled up in his truck, leaned out the window, and said, "You see what they're doing over on the Daly Tract?" The Daly Tract was a 200-acre piece of flat land that had sat undeveloped for years, about a half-mile east of both our properties. Old Harold Daly had passed and left it to his kids, and they'd sold it to a development group out of Austin. I'd driven past a few times and seen the survey stakes, the freshly graded roads, the skeleton frames of houses starting to go up. I hadn't paid it much mind. Developers built subdivisions. That's what developers did. It was their land and their business, and as long as they didn't interfere with mine, I had no reason to concern myself. That was my first mistake. Not paying attention. By the time the subdivision called Whispering Pines was fully built out, 43 homes on what used to be the Daly Tract, and a small adjacent parcel. A homeowners association had been formed, officers had been elected, and a man named Douglas Whitfield had installed himself as president. I didn't know any of this until the letter arrived. It was a Tuesday in March, and May brought in the mail like she always did and set it on the kitchen table. Somewhere in the middle of the usual stack, utility bill, seed catalog, extension office newsletter, there was an envelope printed with a fancy logo, a little pine tree over the words Whispering Pines Community Association. I opened it thinking it was some kind of neighborhood welcome note. Maybe they wanted to introduce themselves. Maybe they were announcing a community event. I read it 3 times before I believed what it said. It was a notice of violation. According to the Whispering Pines Community Association, my property was in violation of the following community standards: exterior structure visibility from common roadways, improper storage of agricultural equipment, unauthorized permanent fencing within the community's aesthetic guidelines, and failure to submit an architectural review application for my barn. The barn my grandfather built in 1953. I put the letter down. I looked at May. May looked at me. And then I did something I almost never do in the morning. I poured myself a measure of bourbon and sat down to think. I want to be clear about something before I go any further. I am not, by nature, a confrontational man. I've spent my entire adult life in a world where a man's word means something. I am proud of the words in Christian man's casting, and where people generally respect property lines because they understand what it means to own land. You've worked with your own hands. I don't pick fights. I don't look for trouble, but I was raised with a very clear understanding that when trouble comes looking for you on your own land, you stand your ground. My first call was to our county attorney's office, not to yell at anyone, but to understand what I was dealing with. The woman I spoke to was helpful. She explained that homeowners associations were governed by their own declaration of covenants, conditions, and restrictions, a CC&R document, and that for those rules to apply to a property, that property had to have been formally enrolled in the association. This meant either the original deed for the property had an HOA covenant attached to it at purchase, or the property had been voluntarily annexed into the HOA through a signed agreement. I told her my ranch had been in my family since 1941. She said then there was absolutely no mechanism by which the Whispering Pines HOA could hold authority over my land. Armed with that, I called the number on the letterhead and asked to speak to whoever was in charge. 2 days later, Douglas Whitfield appeared in my driveway. I want to describe Doug Whitfield because the description matters. He was about 45, medium height, with the build of a man who did a lot of time at a desk and occasional time on a treadmill. He drove a white Tesla, which I mention not as a judgment, but because it was an unusual sight on a gravel road surrounded by pasture. He was wearing pressed khaki pants, a blue polo shirt with a small logo on the chest, and loafers that were already caking with dust by the time he reached my porch. He had the air of a man who was very comfortable in conference rooms and somewhat less comfortable everywhere else. He extended his hand and introduced himself with a lot of confidence, like he'd rehearsed the opening. He told me he was the newly elected president of Whispering Pines, that he was a former municipal compliance consultant from Chicago, and that he was committed to building a community that maintained its property values for the benefit of all residents. I shook his hand. I told him I wasn't a resident. He smiled in a way that suggested he'd expected me to say that. He explained that when the plat for Whispering Pines had been filed with the county, a portion of the surrounding parcels had been included in the association's defined territory. He said it was a matter of geographic boundary establishment, that it was standard practice in community development, and that I would have received notice in my deed transfer, though he acknowledged these things could sometimes be overlooked. I told him my deed transfer had happened 12 years ago when my father died, and there had been no mention of any HOA in any of those documents. He said he understood my concern and suggested we work together cooperatively to bring my property into compliance. I told him slowly and clearly that I was going to speak to an attorney, and that until I understood exactly what legal authority he believed he had over my land, I was not going to comply with anything, and I'd appreciate it if he didn't send any more notices until that question was resolved. He told me that fines had already begun accruing, at $250 per day per violation. I told him he was welcome to accrue whatever fictional numbers he liked, and I showed him back to his Tesla. May had been listening from the kitchen window. When I came back inside, she already had her laptop open and was pulling up the county property records. It took her about 40 minutes. Then she looked up and said, "Cole, our deed has no HOA covenant, not one word, and the Whispering Pines plat was filed 18 months ago. Our property boundary is clearly marked. We're not inside their territory." I nodded. "But someone at the county recorder's office appears to have made a notation," she said carefully, "that your parcel number is listed as an adjacent property under a supplemental association territory exhibit." I asked her what that meant. "It means someone attached a document to the HOA filing that tries to claim your parcel is within their boundary. It doesn't carry legal force on its own, but it might be why they sent the notice." I asked her who filed that supplemental document. She looked it up. The filing had been submitted by the Whispering Pines Community Association, signed by its president, Douglas Whitfield. The man had filed a document with the county trying to attach my grandfather's land to his neighborhood association, without my knowledge, without my consent, without a legal basis that I could identify. And he'd done it 3 weeks before he drove up my driveway to introduce himself. I called our family attorney, a man named Gerald Holt, who handled our ranch contracts and estate matters. I told him what May had found. There was a long pause. Then Gerald said, "Cole, I want you to send me that document right now, because if that filing says what you're describing, we have a problem, and the problem is entirely on his end, not yours." A week later, Gerald confirmed it. The supplemental territory exhibit was, in Gerald's words, legally defective, procedurally improper, and almost certainly filed in bad faith. It had no binding effect on my deed. My property was not and had never been part of Whispering Pines HOA. He drafted a formal letter to that effect and sent it certified mail to Douglas Whitfield. I thought that would be the end of it. I was wrong. Within 2 weeks of receiving Gerald's letter, I got a new round of violation notices. This time, Karen Pruitt had signed them. Karen was the Homeowners Association's compliance officer, a woman in her mid-50s who had moved to Whispering Pines from Houston and who, according to Buck Tillman, had taken to the compliance role like it was a calling from God. She carried a clipboard at all times. She drove a golf cart modified with a small HOA logo on the side, and she had apparently walked the perimeter of my property from the road and generated 6 additional violations: cattle noise disturbance, dust generation affecting neighboring properties, irrigation runoff, unsecured hay storage, unpermitted agricultural lighting, and my personal favorite, failure to maintain landscaping consistent with community aesthetics. I called Gerald. He called Doug. Doug's response, relayed through Gerald, was that the Homeowners Association was exploring legal options and that the formal attorney letter did not resolve the fundamental question of territorial boundary. Gerald told me to document everything. Every notice, every visit, every conversation. So that's what I started doing. Over the next 3 months, the situation went from irritating to genuinely threatening. I want you to understand the financial reality of what was happening. Every day that passed, Whitfield's HOA was accruing fines against my property, fines I didn't legally owe, under authority the HOA didn't legally have, for violations of rules that had never applied to my land. By May, they were claiming I owed over $14,000 in accrued fines. By June, that number had jumped past $22,000. I knew, Gerald had confirmed, that these fines had no legal standing, but that didn't mean they couldn't cause me serious damage. In Texas, an HOA can file an assessment lien against a property for unpaid dues and fines. If that lien is filed and not immediately challenged, it attaches to your title. It can complicate refinancing, sale, and in extreme cases, it can be used as the basis for a foreclosure action. Knowing the lien is fraudulent and fighting it in court are two very different things. The second one costs money and time that a working ranch operation can't always spare. That, I came to understand, was the strategy. Doug Whitfield was not an idiot. He knew his territorial claim was legally shaky, but he also knew that drowning me in paperwork, fines, and legal costs might eventually make compliance cheaper than resistance. Buck Tillman came over one evening in mid-May and sat on my porch with a cup of coffee and told me he'd started getting notices too. Buck's property was even further from the Whispering Pines boundary than mine. He'd received violations for his horse pasture fencing, his equipment storage, and the color of his grain bins. Same playbook, I told him. Buck spit off the porch. Cole, I've been on this land for 30 years. Nobody tells me what color my grain bins are. I told him to call Gerald and get a separate formal response filed. The more properties that formally contested the HOA's jurisdiction, the weaker their territorial claim would look if it ever went to a judge. In July, Doug leveled up his approach. He hired an attorney, Sandra Vance. In July, Doug Preston's community center 5 years ago for Sandy's report. She sent Gerald a letter that was professionally written, well-structured, and considerably more dangerous than anything Doug had put together on his own. It made 3 arguments. First, it claimed that the supplemental territory exhibit, while possibly procedurally irregular, had established a colorable claim of HOA authority over adjacent parcels and was valid until formally invalidated by a court. Second, it cited a Texas HOA statute that allowed associations to seek court-ordered compliance for persistent violations. Third, and most chillingly, it stated that the HOA intended to file an assessment lien against my property within 30 days if I did not enter a compliance and payment agreement. Gerald spent a weekend reading every relevant statute and case he could find, then called me on a Sunday afternoon. "Cole," he said, "Vance is good. She's wrong, but she's good. The territorial exhibit isn't valid, but they can tie you up in court proceedings long enough to hurt you before we get a ruling that says so. I recommend we file a preemptive declaratory judgment action. We ask a court to declare once and for all that your property is not subject to HOA authority. That cuts this off at the root." I asked him what that would cost. He gave me a number. It was substantial, but it was manageable, and May and I agreed that paying it now was better than the alternative. We filed in August. Sandra Vance filed a counterclaim on behalf of the HOA the following week. We were now in active litigation. And somewhere in the middle of all of this, Doug Whitfield decided that the legal process wasn't moving fast enough for him. He started showing up. The first time, it was a Wednesday morning. Hector came to find me out by the creek pasture and said there was a man at the main gate, standing outside it, taking photographs. I drove down and found Doug with a nice camera, methodically photographing my barn, my hay storage, my fence line, and the back of my house. He was on the road, technically public right-of-way, so there was nothing illegal about it. But the message was clear. He was building a documentation file. I put up no trespassing signs, large ones, clearly visible from the road, at every access point to my property. The second incident happened 3 weeks later. May was home alone while I was in town and Hector was out working the back pasture. She heard a vehicle and went to the window and saw Karen Pruitt's modified golf cart sitting in our driveway, not on the road, in our actual driveway, and Karen standing outside the main fence with her clipboard making notes. May went out and told Karen she was trespassing and needed to leave immediately. Karen told her she was conducting an official compliance inspection. May told her that unless she had a court order specifically authorizing entry onto our property, she was trespassing on posted land and May was calling the sheriff. Karen left, but she left slowly, and she didn't stop writing on her clipboard until she reached the road. I called Sheriff Ray Calloway that afternoon. Ray and I had known each other since childhood. His father and mine had gone to the same church. Ray was a careful man, fair-minded, and he knew ranch country and ranch law better than most county attorneys. He listened to everything I told him, asked a few questions, and then said, "Cole, you've got no trespassing signs posted?" I said yes. He said, "Good. Next time any of them set foot on your property without your permission or a valid court order, you call me immediately. That's criminal trespass under Texas law. I'll respond." He also told me something that mattered. He said he'd been getting calls from a few of the Whispering Pines residents themselves, complaining that Doug was conducting HOA business in ways they weren't comfortable with. The association had apparently been accumulating legal fees at a rate the residents hadn't voted to authorize. Some people were asking questions. Doug, it seemed, was not as unilaterally supported as he was pretending to be. The third incident was the one that changed everything. It was a Thursday evening in late September. Hector found a section of our eastern fence line cut, not broken by an animal, not damaged by weather, cut cleanly, with wire cutters, in 3 places. 2 of my steers had gotten through the gap and onto the road before Hector spotted them and got them back. If those animals had been on that road at night and a car had hit them, an incident that has killed people in this county, the consequences could have been catastrophic. I called Ray immediately. He came out, looked at the cuts, and agreed it was deliberate. He asked me if I had any idea who might have done it. I told him I had a strong suspicion. He said he needed evidence, not suspicion. He suggested I install security cameras, which I did. Within the week, May and I had 8 cameras covering every access point and fence line on the property. I also started sleeping lighter, and I started keeping the shotgun closer. October was a month of legal documents. Senator Vance filed a motion for a temporary restraining order that would have prevented me from operating cattle on the portions of my property closest to the Whispering Pines boundary, citing nuisance and noise claims. Gerald defeated it. The judge, a woman named Patricia Hollis, who I would come to deeply respect, denied the motion and noted in her order that the HOA's jurisdictional authority over adjacent properties had not been established and that restricting a ranching operation that predated the subdivision by 80 years was not appropriate on the current record. That was a win, but it was also just a round and a longer fight. What I didn't know at the time, what we wouldn't discover until the discovery phase of the litigation, was that Doug had been telling the Whispering Pines residents a very different story than what the actual legal record showed. According to Buck Tillman, who'd started attending HOA meetings as an observer, Doug had been telling homeowners that both Buck's property and mine were provisionally incorporated into Whispering Pines, that we were delinquent neighbors refusing to pay our fair share, and that the association's legal action was about protecting community property values. He hadn't told them that the territorial exhibit was of questionable legal validity. He hadn't told them that a judge had just denied his TRO motion. He hadn't told them how much the homeowners association's legal fees were accumulating, fees that every resident was ultimately responsible for paying. Trevor Moss was the Homeowners Association's board secretary. He was in his early 30s, had moved to Whispering Pines with his young family about a year after it opened, and he'd gotten onto the board, as far as I could tell, because he'd gone to one meeting and Doug had essentially drafted him. Trevor was not a bad person. He was a man who'd gotten in over his head and didn't know how to get out. He would become important later. May had been spending a lot of time with Gerald reviewing the documents that had come out of Discovery. In November, she called me in from the barn with that particular tone in her voice that meant she'd found something serious. She had the supplemental territory exhibit on the screen, the document Doug had filed with the county to try to attach our property to his HOA, and she had pulled up the county's filing records, and she had the date stamp. Cole, she said. This document was filed 3 weeks before the HOA was officially formed. The HOA didn't legally exist when this was filed. And look at the signature. I looked. It said Douglas Whitfield, President, Whispering Pines Community Association, May said. He signed as president of an association that hadn't been incorporated yet. And there are properties listed in this exhibit, including ours, that were never part of any development agreement. I asked her what she was saying. She said, I'm saying this might not be a mistake. I'm saying this might be fraud. I sat down. Gerald had said the document was legally defective and filed in bad faith. Now May was showing me evidence that suggested it had been deliberately fabricated, signed under an authority Doug didn't yet have, filed to create a paper trail that would look, at a glance, like our property had always been subject to HOA authority. Gerald's response, when we called him, was measured but serious. He said he needed to review everything carefully, but if what May was suggesting was substantiated, we weren't just looking at a civil property dispute anymore. We were looking at potential fraud and possibly a filing of a false instrument, which is a criminal matter in Texas. He advised me to stay calm, keep documenting, let the legal process work. I was trying. I genuinely was. But the fence section got cut again in November. Different location this time, the northwest corner, near Buck's boundary. Same clean wire cuts. We repositioned cameras and added 2 more. And then in the first week of December, something happened that Buck hadn't seen coming. He got a certified letter from Sandra Vance informing him that the HOA intended to file an assessment lien against his property. Not mine, his. Buck called me from his truck, and I could hear in his voice that he was shaken in a way I wasn't used to hearing from him. Cole, he said, I've got a lien of credit against this property. If they put a lien on it, my bank is going to come calling. I can't afford a lawsuit right now. I told him to call Gerald. I also told him not to pay a single cent to the HOA. He said, easy for you to say, you didn't have a bank loan. He wasn't wrong. And I felt the weight of that, the reality that my stand was costing my neighbor something too. I told him I'd cover his legal costs. He told me he didn't need my charity. We argued about it for 5 minutes and settled on a loan that he would never actually repay, and we both knew it. By December, the case had been in litigation for 4 months. The HOA had claimed over $50,000 in theoretical fines against my property alone, and we were heading into the new year with depositions scheduled, both sides preparing for what Gerald thought would be a spring trial date. I want to be honest about those winter months. The stress was real. The financial strain was real. May and I had more difficult conversations in those months than in the previous 12 years combined. There were nights I stood at the kitchen window, looking out at my grandfather's barn, and wondered whether the fight was worth it. Whether it would have been easier to just pay them something, sign something, make it go away. Every time I got close to that thought, I'd think about that barn, about what it had taken for Earl Harmon to build it, about the fact that no man from Chicago in khaki pants had any right to tell me what I could do on land that my family had worked for 80 years. And then I'd go to sleep and get up the next morning and go back to work. That's what ranchers do. The morning of January 14th, I was up before 5:30, same as always. I dressed, put coffee on, checked my phone for any alerts from the overnight cameras, nothing unusual, and stepped out onto the porch at 6 to watch the sunrise over the ridge. It was cold, around 28 degrees, clear sky, frost on the pasture grass. My breath came out in small clouds. The cattle were moving at the far edge of the field, that slow morning drift toward the water. I went back inside, poured my coffee, and sat at the table reading through some notes Gerald had sent the night before about the upcoming depositions. May was still asleep. Hector didn't arrive until 7:30 at 6:15. I heard it. Gravel crunching. Multiple vehicles. That's not an alarm I can describe to someone who hasn't lived on a rural property. When you know the sounds of your land the way I know mine, every bird, every cattle sound, the particular way the creek sounds when it's running high, the way the wind moves through the cedar breaks, an unexpected sound registers immediately and completely. And the sound of 3 vehicles moving up my private drive at 6:15 in the morning was not a sound that belonged there. I went to the window first. 3 vehicles in a convoy. Doug's white Tesla in the lead, Karen's modified golf cart, and a third vehicle, a silver pickup truck I didn't recognize, with 2 men in the cab I'd never seen before. I understood immediately what this was. This was not a social call. This was not an accident. This was a coordinated entry onto my posted private property at a time when they'd calculated I might not be ready for them. I went to the front door and I took my shotgun from its bracket beside the frame, a Mossberg 500, 12 gauge, that I carried every single morning when I checked the fence line. I loaded it, 2 shells, same as always, and I walked around the side of the house. I'm going to be precise about what I did and didn't do, because precision matters. I did not run. I did not shout. I did not point 2 sides and one more reject my comments. Words of the same are the same process of leading under the pressure of the moment. Yet I realized I was my compounding to make a moment with the rest of the moment. I walked to the fence line between my main yard and the driveway approach, and I stood there, and I held the shotgun at a low carry, muzzle down, and I waited. Doug's Tesla stopped about 30 feet from me. The other vehicles stopped behind it. Nobody got out for a moment. Then Doug opened his door. He was holding a manila folder, the kind lawyers use for court documents. He had his game face on, that careful confidence I'd watched him perform before. He took a few steps toward the fence and said, "Cole, we have a court-authorized inspection order. We're entitled to access your property to conduct the compliance assessment under—" "Stop right there," I said. I didn't raise my voice. He stopped. "You are on my private property," I said. "You have posted no trespassing signs to get here. The no trespassing signs are there because the last time I didn't have them, your compliance officer walked into my driveway without permission. I want you to take that document, get back in your cars, and leave my property. Right now," Doug said. "Cole, I understand you're upset, but this order gives us the legal right to—" "Where's that order from?" I said. "What court? What case number?" He opened the folder, he looked at it, he looked at me, and in the silence between us, something shifted. Something in his expression that I could read even across 30 feet of frosted gravel. Karen had gotten out of her golf cart. Now she stopped moving. One of her hands released the clipboard and it hit the ground. I think the sound surprised her more than it surprised me. Trevor was in the passenger seat of the Tesla. He opened his door, took one look at me, and closed it again. The 2 men in the silver pickup had not gotten out at all. "Get off my land," I said. Doug said, "This is not over, Cole." "No," I said, "it's not. But you're going to leave my property while we settle it." He got back in his Tesla. Karen picked up her clipboard with shaking hands. The silver pickup was already backing down the driveway before Doug's door was fully closed. 30 seconds later, all 3 vehicles were gone. I stood there in the cold for another minute, listening to the last of their engines fade down the county road. Then I called Ray Calloway. Ray answered on the second ring. I told him what had happened. He told me to stay put and not to call anyone else until he got there. He arrived in 22 minutes. I showed him the tracks in the frost, the camera footage from the drive approach that clearly showed all 3 vehicles entering past the posted signs. Ray looked at Doug's document, the one he'd claimed was a court-authorized inspection order. Ray read it twice. Then he looked up at me with an expression I recognized as a man choosing his words carefully. "Cole," he said, "this is not an order from Judge Hollis's court." I waited. "This is a document that appears to be styled to look like a court order," he said. "It references your property address and has Whitfield's HOA letterhead on it. But it's not a filing I can find in the court record. It doesn't have a proper case number that corresponds to your litigation, and it doesn't have a judge's signature." I said, "So what is it?" Ray said, "At best, it's a document Whitfield's people prepared themselves that they were hoping would be convincing enough to get them access to your property before you read it carefully. At worst, it's an attempt to impersonate a court order, which is a felony." He called it in. He got on his radio, ran the case number on the document, and confirmed it didn't exist in the county court system. Then Ray Calloway drove to Whispering Pines and knocked on Doug Whitfield's door. I wasn't there for that conversation, but Ray told me about it afterward. That had been formatted to match the court's style for clarity. Ray told him that was not how courts worked, that my property was posted, that what had occurred that morning constituted criminal trespass on posted land under Texas Penal Code, and that Doug was, in Ray's words, extremely fortunate that Mr. Harmon is a calm and law-abiding man, because Texas law gave him considerable latitude in how he could have responded to uninvited people on his property at 6 in the morning. Doug apparently went very quiet. Karen Pruitt called in sick to that day's HOA meeting and did not attend another one after that. Trevor Moss, it turned out, had only been in that Tesla because Doug had told him the court order was real and that Trevor, as board secretary, needed to witness the inspection for the record. When Trevor got home and looked at the document, he called his own attorney, and then he called Gerald Holt. Trevor Moss had been keeping notes, not official minutes, personal notes, on his phone, about conversations with Doug, decisions Doug had made unilaterally, documents Doug had told him to sign. Trevor had been uncomfortable for months and hadn't known what to do about it. That morning on my driveway had apparently clarified things. He agreed to cooperate with our side. Gerald called me that afternoon with a voice that sounded like a man who had just won something large. "Cole," he said, "I think we need to talk about amending our complaint." What happened next moved faster than any legal proceeding I'd ever been involved with, and I'd been party to a few real estate and boundary disputes in my years running the ranch. Gerald filed an amended complaint that added causes of action for fraud, filing of a false instrument, and tortious interference with property rights. He attached Trevor's sworn affidavit, which detailed in precise and damning terms a sequence of decisions Doug Whitfield had made independently, without board votes, without resident authorization, and in at least 2 cases over Trevor's explicit objections. The fraudulent court order was a separate matter. Ray Calloway had referred the incident to the county attorney's office for review of potential criminal charges. I want to be accurate about what happened there. The county attorney ultimately declined to prosecute, determining that the document, while deceptive, didn't rise to the level of a criminal court order impersonation under the specific statute. I didn't agree with that call, but it was their call to make. What it did do, however, was create an official record of the incident that became devastating evidence in the civil case. Sounder Vance withdrew as the HOA's attorney in February. She cited what the Bar Association delicately calls a conflict of interest and irreconcilable differences with her client. What that actually meant, according to what Gerald heard through professional channels, was that Vance had discovered that Doug had given her materially false information about the nature of the HOA's territorial claim when she'd been retained, and she wasn't willing to continue the representation. The HOA spent 3 weeks trying to find new counsel. Nobody in the county wanted the case. They eventually found a solo practitioner who agreed to handle the response to our amended complaint, but by that point the momentum had. Discovery produced everything we needed. The documents showed that the supplemental territory exhibit had been drafted by Doug personally, with no legal consultation, before the HOA was formally incorporated. Email records showed him discussing the strategy of filing early to create a paper record of community territory before anyone could object. There were emails to Karen Pruitt about coordinating compliance visits to generate fine accumulation. There was a message to Sandra Vance, written before Trevor became a cooperating witness, in which Doug described the litigation strategy as bleeding them until they settle, referring to Buck Tillman and me. There was even an email from Doug to 2 Whispering Pines residents who had questioned the legal costs, in which he assured them that the neighboring properties were already technically subject to the HOA, and that the legal process was just formalizing what's already true. That was written 6 months after Gerald had sent the certified letter explaining our legal position, and 3 months after Judge Hollis had denied the TRO motion. He'd been lying to his own residents. The trial was scheduled for late March. It didn't happen. On March 6th, the remaining board members of Whispering Pines, 3 homeowners who had been watching the legal costs accumulate and who now understood the full picture of what Doug had done, voted to remove him as president. Doug contested the vote. There was a procedural argument that lasted about 2 weeks and resulted in a special meeting at which the majority of Whispering Pines residents voted to remove Doug from the board entirely. Doug Whitfield was no longer president of anything. The new board immediately contacted Gerald and opened settlement discussions. I want to tell you I was magnanimous. I want to tell you I was gracious and easy to deal with, and that I accepted a reasonable offer and shook hands and moved on. But the truth is that May and Gerald spent 2 weeks talking me down from a figure that would have left the HOA's operating fund empty for the next decade. May reminded me, more than once, that the people who were going to pay any settlement were the homeowners, the actual residents who hadn't known what Doug was doing, and who had believed his lies right along with everyone else. She was right. She was right, and I knew it, and I let Gerald negotiate. We reached a settlement in April. Under its terms, the Whispering Pines Community Association formally acknowledged in writing that the Harmon Ranch and the Tillman property were not and had never been subject to HOA authority. All fines were voided. All liens that had been filed were released. The HOA agreed to pay our legal fees and Buck's legal fees, a combined amount of just over $47,000. A separate sum was contributed to a fence repair fund for damages to our properties, including the twice-cut fence line, which Doug's own emails had come close to implicating him in, though not conclusively enough to pursue that claim separately. The HOA also agreed to record a corrective deed instrument with the county recorder, formally canceling the fraudulent supplemental territory exhibit. That document, the one Doug had filed to try to capture my grandfather's land, was expunged from the public record. Buck Tillman cried when Gerald called him with the final terms. He would be furious with me if I put that in writing, but it's the truth, and I'm putting it in anyway. He'd been carrying that weight for a year and a half, and when it came off, It came off hard. Doug Whitfield sold his Whispering Pines house in June and moved, I was told, though I can't confirm it, back to Chicago. Trevor Moss stayed in the community, and the last I heard, he was on the new HOA board trying to help the residents dig out from the legal debt Doug had accumulated. There are no more violation notices in my mailbox. Nobody drives up my gravel road uninvited. My grandfather's barn still stands where he built it in 1953, and not 1 inch of the Harmon Ranch is subject to any authority it was never meant to answer to. Some evenings I walk out onto the porch and I look at that barn, and I think about Earl Harmon breaking this ground with a mule and $37, and about my father Raymond, who kept it running, and about everything it cost to make sure it would still be here for whoever comes after me. And I think about the morning I walked around the corner of my house with a shotgun at low carry, and 3 vehicles full of people who thought they owned my history froze on my driveway. I didn't raise that gun. I didn't need to. I just stood on my land and let them understand what that meant. That's the thing about a ranch that's been in a family for 3 generations. It knows how to stand for itself. Sometimes it just needs a Harmon to do the standing. It's been 8 months since that morning on the driveway. The frost melted. Spring came through the hill country like it always does. Slow and green and smelling like cedar and rain. The cattle are fat, the hay is cut, the fence line is intact. Every morning, I walk out of that front door the same way I have my entire life. I pick up my shotgun from beside the door, same Mossberg 500, same low carry, and I walk the fence line, and I check that everything on these 382 acres is exactly as it should be. The no trespassing signs are still up. I figured they can stay there. If you've been fighting something like this, if someone has been telling you that your land, your rights, or your history belongs to them, I want you to hear this. Document everything. Get a real attorney. Don't pay a single dollar you don't legally owe, and stand on your land, because the land remembers who stood for it, and so do I.